Blog Talk Radio.
Welcome to Family Law Talk.
Family Law Talk.
Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic we have today involves a discussion about the choice of school. In other words, what school will children attend? And what we're really referring to in particular is this, in child custody cases, there can be lots of complex issues. Parents can oftentimes be worried about physical custody. They can be worried about things like legal custody in terms of who makes decisions for kids. There can be a multiplicity of issues out there when you get into specifics about custody schedules and times and days of the week where parents will have the kids with them versus the other parent. There can be issues related to things like daycare, maybe medical decisions. But one issue which can crop up in a lot of child custody cases is really the issue of school. So in other words, what school will the child or children attend either after a divorce or maybe if the parents were never married and it's a custody case between unmarried parents, commonly referred to as a paternity case. There can be a big discussion about, or a big debate in a lot of cases about what school the kids will attend. Now, in lots of cases, the parties are able to agree. This isn't a big issue. The parents are on the same page. But there are cases where that is not the case at all, and the parents could really have a big disagreement. There can even be significant disagreements. In some cases, you'll see homeschooling, like one parent wants to homeschool and maybe the other parent's against it. That can be quite really the litigated issue out there as well. But take in situations where the parties both want the kids enrolled and really attending a school full-time, and just looking at that issue uniquely, and take a situation where maybe the mother wants the kids to attend one school and the dad wants the kid to attend another school. The question is really what do courts look at? What factors can be big in the eyes of a lot of judges out there? And that's what I really want to focus on here today. And having said that, I just want to preface this by saying as well, the laws in every state can vary quite a bit. So you want to be cognizant of the state in which your case is in. You certainly want to be sure you talk to an attorney who's licensed and competent to practice law in your specific jurisdiction. Because, again, there might be different nuances. There might be different factors that courts in your jurisdiction look at that you want to really be cognizant of. And I'll just state this as well. In a lot of these cases, judges have a considerable amount of discretion in really determining what's in the best interest of children in the case. And so it's very important as well to consult with an attorney because as it relates to judges, different judges can sometimes focus on different things, and to certain judges there could be certain factors or criteria which can be particularly important to them. So it's definitely important to have an attorney that can help you in your jurisdiction because, again, what we're going to talk about today is really just some general stuff, some general principles, and these are some things I have personally seen in some cases in which I've been involved and my firm's been involved. And so, again, where we're going with this is sort of a more general discussion about it. And, again, get with an attorney about your specific situation because there can be lots of different variables. But let's talk about some principles out there, some things courts can look at. And I'll just state this as well as a follow-up to the episode. You can go to familylawheadquarters.com. We have an article dated February 21st, 2016 titled, What School Will the Children Attend? And so as a follow-up, you can definitely check out that article. That article goes through a lot of the items in which I'm going to discuss today. But one big issue is in a lot of cases the kids might be attending a particular school, right? So maybe a divorce takes place or gets filed, or maybe a custody case ensues. Maybe it's unmarried parents that were living together but they've split up, or maybe they were never together and a case gets filed. But let's say kids are already attending one school and they've been in that school for a while maybe, and that's a school in which the kids have been attending. That can weigh big in the minds of lots of judges as a general principle. I mean, generally speaking, and at least from my experience, courts can be reluctant to switch the school that kids have been attending, that they've been enrolled in. You know, I mean, and if you just think about this practically at times, you know, kids get used to their particular teacher or teachers. They develop friends and relationships with other school students, and so it can be quite hard for kids to change schools. So if kids have already been attending one particular school, it can be, frankly, an uphill climb for a lot of parents who might want to switch the school that the kids are already attending. So that's one general principle. One thing that can often be looked at in these cases is that continuity is oftentimes an important thing, and certainly a factor that lots of judges look at in cases where the kids have been attending one particular school. Now, on the other hand, there's some cases where maybe the children are young and they haven't started attending school yet at all. Like maybe the custody case ensues, the kids aren't even of school age and they're young, and they haven't been at a particular school. Now, that can lead to a totally different analysis in a lot of cases, because here the kids aren't used to any particular teachers. They're not used to other kids where they have friendships or relationship with these kids. And so in those cases, the choice of school can oftentimes be much more wide open. And in those cases, then the courts are really looking at it from a ground level, and there can be a lot more variance in terms of the way this can ultimately pan itself out. Now, custody in Missouri, where I predominantly practice, and in most states, comes down to what's in the best interest of the child, ultimately. So what's in the kid's best interest, what's going to help them become the best possible students and help them become the best possible adults when they graduate from school and enter the workforce, is ultimately what most courts are looking at in terms of the choice of school in a lot of these different cases. Having said that, when you get into the specifics of schools, specifics of schools really can have a big bearing. So take cases maybe where there's a significant challenge for a child or children. Maybe a child has a particular learning disability. Maybe they can have some sort of medical condition which could ultimately have a bearing on their learning. These can be significant issues and can become significant challenges. Sometimes maybe a child has been attending a particular school and they've been going there for a while, but maybe they're not doing well at all. In some instances, they might not be doing well because, again, they might have a significant educational challenge. Maybe they have a learning disability. Maybe there's a medical condition out there, and maybe the school isn't either meeting the need of this particular child, this specific special educational need, or maybe the school, in theory, doesn't have the ability to do so. And that can be certainly a situation in some cases. So in some cases where you have specific educational needs out there, and the issue is that the child isn't really succeeding in the school, and maybe it comes down to the school being unable to meet the needs of this particular child. In a lot of these cases, really an educational assessment can be important by an educational professional, and that can be significant in some cases. So in some cases, judges might request that the parties do this, which is have an educational assessment done to really determine what's in the best interest of a child. Sometimes a child's not doing well in a particular school, but there might not be a reason to make a change. In other words, a school is maybe meeting the needs of the child. Maybe the school has the facilities and the teachers and really the special programs out there to meet the needs of this child, but for whatever reason, the child's still not doing well. Sometimes this can relate to issues outside of school in theory. Sometimes strife on the part of a family can be an issue. Sometimes it can be an outside of school situation like homework not being completed, maybe in one parent's home versus the other, or the environment of one parent's home ultimately can have really a trickle-down effect on the child and their success. But again, in a lot of cases where there's a special educational need, it's important to have an educational assessment done, and the educational assessment can get to the bottom of the situation. In other words, recommend, is a school change needed? Is a school change not needed? Maybe it's a situation where the child doesn't need a school change, but maybe they need tutoring outside of school. Maybe they need some other assistance outside of school, but maybe inside of the school. And maybe the recommendation is ultimately by the educational professional that the child remain in the same school. Sometimes there can be situations where maybe the educational assessment comes to the opposite conclusion, that at the end of the day, the school change is needed in order for the child to succeed and do better. But again, educational assessments, definitely something to think about, definitely something to consider in a lot of cases, because this can be an aid to the court in certain cases in terms of helping provide a recommendation for what's in the best interest of the child. In a lot of these cases, a guardian ad litem gets appointed by the court. In other words, a court-appointed attorney to help represent the interest of the child. In these school cases where there's a dispute over schools, the guardian ad litem can oftentimes help the court a lot. They might do things, for example, like talk to teachers, talk to counselors, maybe the child's in counseling, for example. Maybe medical professionals need to be talked to, and of course the parents. And oftentimes a guardian ad litem can help make a recommendation to the court in terms of what's in the best interest of the child as well. And from my experience in these complex cases where there's a dispute over the school a child will attend, guardian ad litems are oftentimes appointed, and the guardian ad litem can help perform an evaluation. Other things that I've seen courts look at in particular cases in terms of making choices of school would be things like this. So you look at data regarding a school or a school district. So things like graduation rates can be one thing a court might look at. Maybe standardized test scores might be something that's looked at as well. And then just overall school rankings in terms of where a school is ranked. In some cases, the choice of school difference, when you look at the standardized test scores and the rankings, might be minute. In other words, the schools are ranked very similarly. There's not a big difference. But in some cases, there can be really a wide discrepancy. In other words, when a court looks at the different school options that are out there, one school is just substantially better than another school. And that, in some cases, can be a factor that courts ultimately look and rely on as well. Finally, the issue of payment can come into it as well. In a lot of these school cases, private school can come into play. In other words, one parent wants the child to go to private school versus, let's say, a public school. And in these cases, payment of private school is an important factor. So who's willing to pay for private school? And how much does it cost, and are the parties even able to pay it, can ultimately be a big situation or a big factor that courts look at in terms of the school issue, uniquely in cases where you're dealing with a public versus a private school. And then you get into some specific legal requirements in terms of when a court could order an unwilling parent to pay for private school or not. And that's a complex topic as well, and the laws can certainly vary by state on that particular topic. Typically in Missouri, if a parent is unwilling to pay for private school, there's some cases out there that talk about a special educational need being a factor or a requirement, if you will, for a party to be ordered to pay for the cost of private school, where there's a public school available that can meet the needs. Obviously, that's a complex topic, very intricate, and definitely one you'd want to talk to an attorney about if this is something that might affect you. So again, interesting topic. What school will children attend? As a follow-up to the episode, go to familylawheadquarters.com. Check out the article dated February 21st, 2016, titled, What School Will the Children Attend? That concludes our topic today. Thanks for tuning in. Stay tuned to our next topic on Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision that should not be based solely upon advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtain on this podcast is not, nor is it intended to be legal advice. You should contact an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. And finally, past results afford no guarantee of future results, and every case is different and must be judged on its own merits.
Kirk Stange is responsible for the content. Principal place of business, 120 South Central Avenue, Suite 450, Clayton, Missouri, 63105.
Did you miss your deadline to renew your Medicaid coverage? You can still send your completed annual review form to Healthy Connections Medicaid. You may be assigned to another health plan, but you can ask to come back to First Choice within 60 days of renewed Medicaid eligibility. It's your family. It's your choice. First Choice is the right choice. Renew and choose us. Visit selecthealthofsc.com/renew to learn more.
Why don't more infant formula companies use organic, grass-fed whole milk instead of skim? Why don't more infant formula companies use the latest breast milk science? Why don't more infant formula companies run their own clinical trials? Why don't more infant formula companies use more of the proteins found in breast milk? Why don't more infant formula companies have their own factories instead of outsourcing their manufacturing? We wondered the same thing. So we made ByHeart, an infant formula company on a mission to get a lot closer to the most superfood on the planet, breast milk. Our patented protein blend has more of the important and most abundant proteins actually found in breast milk. We're the first and only U.S.-made formula to use organic, grass-fed whole milk, not skim. We even conducted the largest clinical trial by a new infant formula company in a quarter century, with clinically proven benefits like easier digestion, less spit up, and softer poops versus a leading infant formula. And we make our own formula in the USA and our very own factories in Iowa, Oregon, and Pennsylvania. ByHeart, a better formula for formula. Learn more at byheart.com.